Good morning, ladies and gentlemen. Court is now in session. Bukit Arena Sdn Bhd versus Wong Seng and others is now in session. Is the appellant ready?
Yes, Your Honor.
Is the respondent ready?
Yes, Your Honor.
Members of the jury, your duty today will be to determine whether the defendant is guilty or not guilty based only on facts and evidence provided in this case. The prosecution must prove that a crime was committed and that the defendant is the person who committed the crime. However, if you are not satisfied of the defendant's guilt to the extent, then reasonable doubt exists and the defendant must be found not guilty. So now we will hear opening statements from the appellant.
Alright, thank you. Good morning, Your Honor, ladies and gentlemen. I am Nur Shafia Nadira, who will be here as the lawyer for the appellant, Bukit Arena Sdn Bhd is the legal registered owner with undisputed title to the lands. Plaintiff has found that the defendants have encroached upon, used and operated the said land illegally and without any tenancy, license, permission or consents from the plaintiff, either express or implied. Thus, the plaintiff alleged that the defendants have received unjust enrichment as a result of their action. Accordingly, the plaintiff has issued a notice to vacate the premises site owned by Syarikat Bukit Arena Sdn Bhd on 8 September 2014 to the defendants. The plaintiff has asked the defendants to move out and return possession of the said lands to the plaintiff. Further, the plaintiff, through his solicitors, has issued a vacancy notice date 2 August 2019 to the defendants to restore possession of the said lands within 1 month from the date of the vacancy notice, which expired on 1 February 2019. All these efforts of the plaintiff did not yield any result. Thus, plaintiff has acted to file this application.
Thank you, Counsel. So now we will hear opening statements from the respondents.
Good morning, Your Honor, ladies and gentlemen. I am Nur Ain Nadira, who will be here as the lawyer for the defendant, Wong Song, Cho Boon Leong, and Yap Yu Kin. They claim that they had developed and cultivate the said land for agriculture and livestock since the 1940s under the knowledge and consent of the Perak state government, which was the owner of the said lands before the plaintiff.
Thank you, Counsel. So, appellant, what is the evidence to show that Bukit Arena Sdn Bhd is the rightful registered owner with undisputed title to the land?
Yes, sure, Your Honor. This is the title deed of the lands.
Your Honor, here there are doubts about the acquisitions of the lands by the plaintiff for failing to submit documents such as receipt of payment of temporary occupancy license, approved state lease document as well as valid document from the Perak State Land and Mines Office. All of these doubts indicate that there is a chain of persistent invalidity or obvious misstatement on the part of the plaintiff. This refers to the case of Tai Tong Flowers Nursery Sdn Bhd versus Master Parodo Sdn Bhd in year 2014, Section 9 CLJ 74, and then Gula Perak Berhad versus Datuk Lim Su Beng and other appeals in year 2019, Section 1 CLJ 153. Based on the concept of conclusive legislation, evidence anyone, including those who have successfully registered land in an illegal manner, their title is also inviolable unless it is shown that the transfer was obtained by fraud or forgery, as provided in Section 340, Section 2, for example, uncertainty of title or interest acquired under Section 340, Section 1, however, can be set aside under Section 340, Section 2, where it has been obtained fraud or forgery.
Sorry to interrupt. I don't think so. In the case of Tai Tong Flower Nursery Sdn Bhd, the defendant has raised the issue of invalidity of the registration of the plaintiff as the legal registered owner of the land with reference specifically to Section 214A KTN 1965, while in this case, the first, third, and seventh defendants fail to state specifically whether the provisions of the law have failed to be complied with or have been violated by the plaintiff, so as to cause the disposal of the lands to be tainted with invalidity. Apart from that, Section 214A KTN 1965, which is in dispute in the case of Tai Tong Flower Nursery Sdn Bhd, is not applicable in this case because Section 214A KTN 1965 only applies to estate land, while in this case, the lands are not estate land.
Thank you, Counsel. So, respondent, please show evidence that shows that the defendant is entitled to the occupation or ownership to the lands. If the first, third, and seventh defendants succeed in showing that they are entitled to the occupation or ownership of the said lands, then it amounts to issues to be tried and it is not suitable to be decided in this application.
In this case, the first, third, and seventh defendants have submitted document of the first defendant's application to the office of the Director of Lands and Mines of the state of Perak to be given land to cultivate cattle and fish. Next, certificate of participations and appreciations received by the first defendant in related activities. Lastly, letters from the Department of Agriculture allegedly stating that the first, third, and seventh defendants were active agricultural entrepreneurs on the said lands. On the other hand, the first, third, and seventh defendants have referred to the several authorities to support his argument, namely Bohari bin Tai versus Selangor Director of Mineral Lands in years 1991, Section 1, CLJ Rep 48, and then Salim bin Ismail versus Levi Sdn Bhd number 2 in years 1997, Section 1, CLJ 102, and Juta Perman Sdn Bhd versus Muhammad Zain Jantan and owners in years 2001, Section 2, MLJ 322.
In the case of Bohari bin Tai, the defendant submitted evidence showing that they had been granted temporary occupation license from 1981 to 1983, and there was approval from the State Executive Council to them on 4 September 1980, whereas in this case, there was no such fact. Other than that, in the case of Salim bin Ismail versus Lebe Sendirian Berhad, the state government has full knowledge of the existence of the village and has encouraged exploration in the area by providing some public facilities is not disputed by the parties in the case, whereas in this case, there is no such fact. Subsequently, in the case of Juta Permai Sendirian Berhad, the state authority gave permission to the defendants to occupy the land from the Deputy Menteri Besar of Selangor, and the decision of the state authority confirmed that each of the settlers and residents of the area should be given 8,000 square feet of land each, whereas in this case, there is no such fact.
So, respondent, you have any objection from that?
No.
So, taking into account all that has been stated above, I make the finding that there is no evidence that has been submitted by the first, third, and seventh defendants to show that their application was ever approved. The first, third, and seventh defendants also failed to show that they had obtained permission or acknowledgement from the state authority to continue to occupy and cultivate the land.
Your Honor, the first, third, and seventh defendants have submitted a later date, 19 October 2015, from the plaintiff himself stating that the seventh defendant was given permission to continue to occupy and cultivate the said lands by the plaintiff himself upon payment of annual rent. Nevertheless, there is an exception in KTN 1965 which allows that ownership of the registered owner to be denied. Under Section 340, Section 2, KTN 1965, it is provided that the right or interest of any such persons or bodies shall not be allowed. In any case of fraud or misrepresentations of which the person or body or any agent of the person or body is a party or secret, and then where the registrations was obtained by forgery or by insufficient or invalid instrument. Lastly, where the title or interest was unlawfully acquired by such person or body in purpose exercise of any power or authority conferred by written law.
Your Honor, the plaintiff has never given permission to the defendant to continue to reside and work the land. Plaintiff also never received annual rent payment from the first, third, and seventh defendants. The plaintiff in the said reply affidavit 2 has denied and disputed the fact posed and asked the first, third, and seventh defendants to submit any proof of payment of the said annual rent of the court if true.
So, respondent, can you show proof of annual rent payment?
We have no that evidence, but I make it clearly. The case may not have arisen if the plaintiff, the company Bukit Arena Sendirian Berhad, can hold an advertisement to make a site list on the land. It will also make other things that the land is not cultivated like there is no owner. It is better to cultivate at least to be able to produce lucrative result. Because of appellant's negligence, we claim the right to continue to be and work at the land as usual. Referring to the judgment of the Federal Court in case of Tehbi versus Murutamutu in years 1977, Section 1 LNS 134, non-compliance with the provisions of the law relating to the manners of acquiring title to government land shall not render the registration invalid, but if the breach is from an essential and fundamental provision for the existence of state authority powers, where it can agree to the alienations of state land. In other words, if it is not merely non-compliance with the procedure, but where the state authority intends to act to pursue a power that is not provided anywhere in the national land code, that I think that registrations of right property that follows the illegal actions of state authorities is illegal and void.
Thank you, appellant and respondent, for the submission presented just now. The verdict has been made by the court considering the circumstance and evidence addressed. I hereby, due with respect, accepted the plaintiff claim as the defendant found guilty of committing fraud in using the land rights of others, relied on National Land Code subsection 214 under the control of transfer of estate land. So plaintiff prosecution was accepted and defendant was found guilty and sentenced. The court may disperse. Thank you.